Good afternoon, everyone, and welcome to this latest edition of the Encompass webinar series. My name is Chris Shipley, and I am the Association's Executive Director of Public Policy. Today, we're pleased to bring you De-Risking International Section 214 Authorizations, a webinar on the Federal Communications Commission's recent efforts to place a heightened focus on how to leverage oversight of international Section 214 authorizations to advance U.S. national security, foreign policy, trade, and law enforcement concerns. Here to lead our discussion on the new landscape of FCC and team telecom regulatory oversight faced by the telecommunications industry and infrastructure investors are two experts in the field from Morgan Lewis, an Encompass Marketplace member and one of DC's most prestigious law firms. Ulysses Pinn, a partner in the DC office, counsels clients on foreign investment, national security, export controls, international trade, and embargo issues before the FCC, CFIUS, the Office of Foreign Assets Control of the Treasury Department, and the Departments of Commerce, State, Defense, Homeland Security, and Justice. Ulysses is joined by Patricia Cave, an associate in the DC office and a former classmate of mine at Catholic Law School. Patricia counsels clients on matters related to domestic and international licensing, broadband infrastructure, national security regulations impacting telecom providers and equipment vendors, and export control matters. This has been a topic of significant interest among members, and Encompass is thrilled to have Ulysses and Patricia here to help our participants mitigate the risks associated with the FCC's new data collection and regulatory proposals. Before we get started, one piece of housekeeping. Comments and questions can be entered into the Q&A feature below. We'll address those following today's presentation. With that, it gives me great pleasure to welcome Ulysses and Patricia to get us started.
Thank you very much, Chris, and thank you very much to Encompass for having us. We are thrilled to be here and talk a little bit about the FCC's new efforts with respect to foreign investment in the telecommunications sector. In particular, we're going to spend some time talking about this document. It's 186 pages that the FCC released in April of this year that contains two things. One is two items. One is an order which will be a request for information from Section 214 holders, and the other is the initiation of a notice of proposed rulemaking in order to change certain rules with respect to foreign investment in the telecommunications area and disclosures of foreign investment in the telecom area. Patricia and I are going to briefly talk first on a little bit of the background on the FCC and how they have seen national security and foreign investment over the years, how this has been evolving. Second, we're going to be talking about the order piece, which will have a reaction by parties or a need to react as soon as there's some procedures established in the Federal Register. And then the third, which is more of the longer term prospective changes in the rules and how the FCC will likely modify its existing rules on how companies holding Section 214 authority will need to provide information or renew their existing licenses. So with that, I'll take the first part of the presentation and then I'll hand it over to Patricia for the second part. Foreign investment in the US is not new at all, but this has been an evolving topic, and we have titled our presentation De-Risking International Section 2 Authorizations, because this is nowadays the term that is being used or tossed around in Washington. We're not decoupling from the world, but we're trying to de-risk the industry or investment from certain jurisdictions that may be problematic due to geopolitics or the like. So this is an area that has been evolving over the past, I would say, at least 20 years with what has been known as Team Telecom. Team Telecom was an ad hoc group of agencies led by the Departments of Justice, Homeland Security, and Defense, including the FBI, that basically looked for national security and law enforcement issues with respect to FCC applications. The FCC, on an ad hoc basis, probably starting in the early 2000s, most prominent case that I can remember was probably the Global Crossing's emergence from bankruptcy in 2003, when Team Telecom actually made its first big big splash with certain changes to the Singapore telephone acquisition of Global Crossing at the time. And for many years, we had the people in the bar and companies that have foreign investment had to deal with Team Telecom on an ad hoc basis. The FCC referred applications to the committee on an ad hoc basis with no specific rules. But that all changed in April of 2020 with the passage of Executive Order 13913, which creates the, this is a mouthful, I have to read it, Committee for the Assessment of Foreign Participation in the United States Telecommunications Service Sector. We, for short, we and them, the government itself refers to themselves as Team Telecom. So we continue to refer to it as Team Telecom, but this has now provided structure as to how the process works. It talks about an initial review, as well as a secondary potential review, and coordination between government agencies continue to be led by the Department of Justice and with significant participation by Homeland Security and Defense over the review of all applications, including Section 214 licenses and others that have any level of foreign investment and that the Commission refers to them. Over time, the risks have been changing, and China and Russia, I would say, are the biggest issues that are of concern with the FCC as well as Team Telecom. Starting with Senate Subcommittee of Investigations, actually warning that a few years back that Team Telecom and the FCC needed to redouble their efforts in this area. This has led to a few actions by the committee and by the Commission over time. Christian, next slide, please. That have resulted in, for instance, the denial of a license application by China Mobile International, which was denied in 2019 by the FCC after a recommendation by Team Telecom. The application had been waiting or dormant for about 7 years. And then in 2019, it was eventually denied by the FCC, as well as a revocation of Section 214 authority for China Telecom Americas and China Unicom Americas and CITIC, which were government owned by the government of China in the years 2021 and 22 at the recommendation of Team Telecom. Basically, Team Telecom and the Commission have identified that we have an evolving national security risk, particularly with with China and the Chinese Communist Party, and have deemed that these companies should not have Section 214 authority. Obviously, this has evolved as well, and over time, the FCC has put more emphasis on the revision or the review of foreign investment in these areas, and has had some enforcement in the area. Next slide. I want to spend a little bit of time or just call your attention to one of the most recent cases on enforcement with respect to foreign investment or lack of disclosure of foreign investment is the TruePhone case, when as a result of the Ukraine conflict in February of last year, in April of 2022, the FCC issued a notice of apparent liability to TruePhone Inc., a company that apparently had some undisclosed Russian and Cypriot ownership that had not been approved by the Commission, and had not been vetted by Team Telecom. After a somewhat lengthy process, the FCC was charging them with violations of Section 214, Section 310 of the Communications Act, and after a process, the parties enter into a settlement agreement and a consent decree, basically performing for a penalty or a payment of $600,000. So it is not an insignificant amount of monetary forfeiture that this company had to pay, as well as the implementation of a remedial plan and the divestiture of the ownership stake by those Russian owners that had not been previously approved. So I think we're just sending this as a lesson to industry that the Enforcement Bureau and the FCC are active in this area, that they definitely are very wary about non-notified changes of ownership or transfers of control. And this is an area that licensees must be very careful of, always making sure that they comply with FCC rules. Otherwise, they may be facing potential significant fines. And not only the fines, but also the reputational risk and the cost of investigation, which in many cases are much higher than what the forfeiture from the FCC may be.
And in terms of, there are some states where you need to disclose non-compliance with other regulatory regimes or enforcement actions against you. So in the event that the FCC could find you in violation of the FCC rules for an unauthorized transfer of control, you could have state implications for that, as well as needs to disclose that moving forward for additional applications at the state level.
Absolutely, and also for privately publicly traded companies that may have disclosure obligations to the world, you may need to trigger, 8Ks or other public advisories that you're in the process of defending these allegations or selling these allegations, and this may have an impact on the company's share price or other market for your securities. So this is something that could be problematic for a company, and compliance is important. So the next topic we want to briefly talk about is the first of the two items included in the FCC's release in April of this year. And this is the order, which is a one-time data collection order, which would require any Section 214 holder to provide certain information to the FCC. By way of background, or what the Commission has noted in their order, is there are apparently about 7,000 Section 214 international licenses that the FCC has granted over time. These licenses do not currently have an expiration date, or are otherwise terminable or cancelable by the Commission under circumstances other than default by the applicants, or other very, very few cases. So there's many licenses that either are not being used, or that the records of the Commission are incomplete and do not reflect whatever the current ownership of those licenses is. So what the FCC's Office of International Affairs, which is now half of the former International Bureau, which was recently reallocated by the FCC to create the Space Bureau and send all satellite activities to the Space Bureau, and retain the licensing and oversight of submarine cables, as well as Section 214 licensees with the Office of International Affairs and some of the staff there. They're trying to do a one-time data collection from operators, and they are focusing particularly at on the foreign ownership of those data collectors, of those licensees. I'm sorry. Basically, we would need parties, whenever this order comes into effect, and we'll talk about what the current status is. Parties would need to do a disclosure of their foreign ownership at the 10% or higher level of any beneficial owner, not just a direct owner, but somebody all the way up the ownership chain that may have a foreign interest. And we would need to disclose in three big categories. First of all, what percentage of ownership, if any, is held by what the FCC calls foreign adversaries. And foreign adversaries are identified as basically countries with which the US has generally established sanctions or trade controls, like Cuba, Iran, North Korea, Venezuela. But there's also, and Russia, and also China, which is not subject to, or Hong Kong, which are not necessarily subject to US sanctions, but which, due to geopolitics and the current situation we're holding, is deemed by the US FCC and other government agencies like the Department of Commerce, etc., as a foreign adversary in certain effects. So parties would need to disclose if they have any ownership from these countries, or if not, if they have any foreign ownership from any other countries and at what levels, or if they're totally American owned. The FCC, as part of this exercise, would be requiring parties to show all the way to individual holders or publicly traded companies that are dispersed, that they don't have a beneficial holder that would have a 10% or higher interest in the licensee, no matter what levels, how many levels they have. And they would need to see whether there's any dual citizenship. People may have, for instance, UK nationality and Iranian nationality. So they would need to disclose that person under both scenarios, right? As for an adversary as well as under general. And they would need to provide background information on these shareholders. The idea, next slide, please. The idea is that this would be a one-time, relatively minor. I think the FCC is trying to, this is going to impact potentially up to 7,000 responses from licensees. I mean, we don't expect them to be that many active 214 holders. Many companies actually currently have, or groups of companies hold more than 1, 2, and 4 license in their portfolio. And they make one of the plans that Patricia is going to be talking about is for companies to only have 1 214 license rather than having multiple in the organization due to prior mergers or acquisitions, or why companies may have had multiple licenses. And some others may be dormant. But the idea is that the FCC will be asking, whenever this order comes into effect, the parties to respond. And parties may, to the extent that a party does not have any foreign ownership, or has not had a change in those, it has been reviewed by the Commission in the relative short term or in the past 3 years, applicants or companies may be subject to less onerous requirements. They may only need to disclose what the transaction was or when the license was granted, and if there have been no material changes, we don't know exactly what would be the data collection order, but likely it will be at the 10% or higher level. If the same facts and circumstances as previously disclosed to the FCC remain the same or haven't changed, the goal is to not have a significant burden on operators. Others that have had their licenses for longer periods of time, or may need to provide additional information about the licenses. What would happen if you don't respond? And we'll talk about it in a minute. The idea is anybody who does not respond, the FCC is going to give them another warning, most likely. But the idea is that they will cancel the license. As an alternative, particularly if a company is not using their license, or doesn't want to disclose or doesn't want to go into these issues. Many companies have held or hold these licenses in their portfolio, but their current operations do not require a Section 214. There's always the alternative to give back your license. It's turning back an international Section 214 license. It's very simple. It's a 3-sentence letter. You file it electronically. The FCC acts on it very quickly thereafter. The effective date is generally the date of filing. I mean, unless you have some discontinuance issues that you need to think about under the discontinuance rules. But if the company is indeed not providing services under this license or marketing service, giving the license back is relatively straightforward.
I think the only caution with surrendering the license is considering whether maybe you don't have operations now that require that, but maybe you have business plans in the future where you may need to have the international Section 214. And if you have foreign ownership, you could be falling into a Team Telecom lengthy review process on a subsequent license application in the event that you want to start entering into a business that requires it.
That is an excellent point. The Team Telecom process, just for background, is generally taking approximately currently about 6 months from beginning to end, from the filing with the FCC until the clearance by Team Telecom. The process in front of the committee is about 120 days if there are no particular circumstances, so they don't need a second stage or second review for an additional 90 days. But generally, how it works is you file with the FCC refers the application back to Team Telecom, and Team Telecom asks the parties a series of questions. Once the questions are deemed complete, Team Telecom would start their clock, and that starts at 4 months or 120-day clock. So we're seeing about 6 to 7 month processing time right now for most applications. There may be others that may be a little more complicated or may require a little more, several rounds of questions at the outset. But to Patricia's point, if the company's plans may change or you may need to keep that, it's important to take into consideration that getting licensed again under a section 214, it's going to take some time if there's any reportable foreign ownership at 10% or higher level. So the next slide is just the timing. As we noted before, the order was was adopted by the FCC on April 20th. It was released shortly thereafter. And it's currently like under the Administrative Procedure Act, they have requested emergency approval for data collection. The FCC is working with the Office of Management and Budget. They have published in the Federal Register on May 3rd, 2023, the initiation of this process. And eventually this will culminate with the approval of this emergency authority. And there will be a publication on the Federal Register, and the FCC will then be able to ask this information. The goal is that once this is done, the FCC will issue certain forms that will request the information. We'll have some processes and procedures established, and then parties will have normally 30 days to respond. If, like every good citizen responds to the request of the regulator, companies that do that, likely the FCC will analyze the data, and then they may take it as part of a second notice of proposed rulemaking that Patricia is going to be looking at. They will use that data for either purge their records and improve the records, and or use it for changes in the rules. Companies that do not respond to this are likely going to, the penalty would be potential revocation or cancellation of the license for anybody that does not respond to this request. So it's important whenever this is done, and obviously we at Morgan Lewis, we will be advising our clients when giving you sufficient time and opportunity so that you are aware that we need to do this data collection. This is going to be an effort. In many cases, maybe very simple. You may have nothing to report. In many others, depending on the complexity of your corporate structure, particularly those that are owned by publicly traded companies or funds or private equity funds, which may have complicated corporate structures, getting to the bottom of what percentage is held by whom and what is the current composition of ownership may take some time. So I think it's important once the FCC actually provides the green light for this, for companies to start reacting relatively quickly, because there's going to be a short window in order to react. And the penalty, again, for failure to do that could be significant.
And I think one thing companies can do now, right, Ulysses, is look at any FCC applications they filed in the recent past, maybe their most recent transfer application or assignment that will have already your 10% reportable ownership. So that can kind of give you an idea of where the FCC thinks you are, and you may make some changes so it's up to date.
Exactly. Your baseline should be either your original license, to the extent that you have not undergone a recent or for control or an assignment or license or something like that, recent review by the commission or approval by the commission on an assignment or transfer.
And since we know this is coming, there's no really harm in pulling that information together before we have the deadline, so that you're ahead of the game.
Absolutely. The worst thing that can happen for anybody is to be scrambling with a fire drill at the last second. So obviously being proactive and taking steps in order to be ready for this would be a good policy and a good practice. With that, I'm going to let Patricia walk you through the second part of the item, which is a notice of proposed rulemaking.
Sure, thanks, Ulysses. So as Ulysses mentioned, the item adopted in April included an order for the one-time information collection, as well as a notice of proposed rulemaking, which makes changes to the international section 214 authorization process, including potential renewal of licenses, periodic review of licenses, new requirements for content of international section 214 applications, new areas that Team Telecom may be able to review applicants and licensees. So we're going to review some of the key takeaways from the NPRM now. The first key takeaway we had is that the FCC is proposing a renewal framework that would require international section 214 authorization holders to obtain a affirmative renewal of their license every 10 years. As Ulysses mentioned before, these authorizations historically have been effective until they're surrendered, or the FCC in very limited cases has revoked some of these authorizations, mostly in cases where an entity no longer exists and is not responsive to FCC inquiries. But so this is a major sea change in the licensing regime.
And I just want to say something. The U.S. one was probably one of the very few countries around the world. I practice internationally, and most countries have an obligation to update their licenses. So the licenses have an expiration date for the most part, or our registrations have an expiration date, because regulators have and want to make sure that they have another opportunity to recalibrate or review the application and not have licenses for a long period of time. And also it's also a source of revenue for countries, right? There's licensing fees and application fees. So that's something that happens around the world. Another example is the FCC itself. Other licenses granted by the FCC, for like the submarine cable landing licenses, they do have an expiration date. This is not something that is new. It's something that, for instance, 25 years for submarine cables, which was perceived useful life of a cable. I mean, we have now seen that technology allows cables to continue for more than 25 years, and we're now seeing several systems that are being renewed after the 25 years, and we're going again for new licenses and new Team Telecom reviews. But this is something, just want to say that the FCC in implementing this is not changing or creating something that other countries in the world are not doing. The cost of doing business around the world is periodic license renewals, and the FCC is doing the same.
Yeah. And the renewal process, the FCC is proposing that the 10-year mark would be starting or would take effect every 10 years after you've had any sort of application before the FCC about your international authorization. So maybe that's a transfer of control or an assignment of the authorization, a pro forma filing. So that would be kind of a rolling basis of when you would determine when your 10-year filing is due. The FCC is proposing to prioritize these renewal applications with a potential, pool of 7,000 authorizations. It could become unwieldy for the FCC to try to review all these at one time. So they've set forth a 5-level categorization for prioritizing these applications, really with the key factors being whether you have reportable foreign ownership, if you have a mitigation agreement with Team Telecom, how recently your application or your authorization has been reviewed, and then notably whether your application, apart from any foreign ownership considerations, raises national security, law enforcement, or other concerns, which we'll talk about in just a few minutes. The streamlined processing really would be for those in the Group 5 category. This would be those with no reportable foreign ownership and that don't raise any other international 214 national security or law enforcement concerns. The FCC is proposing that these entities will not file their applications for renewal until after all the applications for the other 4 priority groups have been filed. And if there are no objections, if Team Telecom doesn't intervene to review these renewal applications, then they could be granted 14 days after a public notice is issued accepting the renewal application for filing.
Again, just if I may say so, those that do have foreign ownership, most likely under FCC present and the current procedures that they have, will likely be referred to Team Telecom, and we will be looking at a multi-month processing window for those renewal applications.
Yes, and Team Telecom referral is one question the FCC is asking as far as when Team Telecom approval or referral would be necessary, and they're proposing to require the referral where there's reportable foreign ownership and these 3 additional categories here mentioned on the slide, which we'll also talk about a little later on in the presentation about the use of certain managed network service providers, the use of cross-border facilities and equipment and services that are on the FCC's covered list that was developed under the Secure Networks Act. They are asking, however, questions about whether they should apply their policy of non-referral for certain types of international Section 214 applications, if they should apply that policy here. So we'll see where that comes out. And similar to the failure to submit your information in response to the one-time data collection, the FCC is considering whether a failure to renew should be resulting in an automatic expiration or cancellation of the license. As one alternative to this affirmative renewal and approval requirement, the FCC is considering whether it should adopt a periodic review process on a similar time frame. So rather than requiring an application for a renewal, they may just set up a 10-year periodic renewal or a review process. The second really big issue that we see in the notice of proposed rulemaking that all providers that have these licenses should be aware of is the proposal or seeking comment on reducing the reportable ownership threshold to 5%. Currently, it's a 10% threshold, so any entity with a direct or indirect interest of 10% or greater needs to be disclosed, and the FCC is seeking to have disclosure of more owners at a lower level of equity or voting interests in order to capture really minority interests that the FCC thinks could be accompanied by certain control rights. The NPRM references the concept of golden shares, where an investor may have 1% of the equity, but they could have, outsized influence on the board of directors, for example. This was one area where before the NPRM was adopted in April, there was significant lobbying by different entities, including some investors in this telecommunications area, who felt it was important for the FCC to retain, or at least propose to retain, the 10% threshold.
This is an area that private equity funds or others, maybe we may have a fund that is actually in control of an investment, but they may be raising capital from sovereign wealth funds or from other insurance companies or banks from abroad. Obviously, capital has generally no borders, and many times there may be a number of investors that are in these 5 to 10% that may need to be reported, etc. Even if those investors have absolutely no bearing or no control whatsoever with the day-to-day operations of a licensee. So this is something that particularly for publicly traded or private equity-backed companies, it may be something that may create significant additional disclosures. And as Patricia was saying, there may be some parties that have already addressed the commission and maybe addressing them in the future in order to maintain the current level of 10%, which has been historically the level that has been maintained by the FCC and other regulators in order to disclose beneficial ownership.
Yeah, and following some of that initial advocacy, we did see a change in the language in the draft notice of proposed rulemaking compared to the final notice of proposed rulemaking that ultimately was adopted. The initial draft really had a strong proposal of reducing the threshold to 5%, and the NPRM is a bit more muted in how it seeks comment in that proposal, rather than affirmatively suggesting that should be the proposed rule moving forward. And in addition to the shift in the language, the final NPRM also added some alternatives, including whether reporting at the 5% level should just be required for uninsulated or non-passive investors. This is a proposal that's similar to the rules that already apply in the Section 310B foreign ownership petition for declaratory ruling context, where if you are an uninsulated interest that you're at 6%, you need to be disclosed. But if you're an insulated interest at 6%, you do not need to be disclosed or specific approval sought for you. There also is another alternative of just requiring disclosure of 5% investors who are from the foreign adversary countries, which Ulysses mentioned earlier includes China, Russia, and countries on that list. There were some also concerns regarding confidentiality, and the FCC is seeking comment on how those concerns can be addressed, either through providing presumptive confidential treatment of certain of the ownership information, or just requiring direct filings with Team Telecom, which already has a 5% ownership reporting threshold. But notably, those Team Telecom processes currently are entirely confidential.
All right, that's an important thing. Everything with respect to ownership and disclosure in front of the FCC is an entire open book and fully open to the world, whereas processes in front of Team Telecom or the Committee for Foreign Investment in the U.S. CFIUS are generally maintained under confidentiality, and the information provided therein is not subject to the world review or subject to FOIA disclosure.
Yeah, and one key aspect of this reportable ownership threshold change is that it would only apply to international Section 214 authorization holders. So submarine cable landing licenses that don't have a 214 accompanying them, or carriers that just have a domestic Section 214 authority, they would not be impacted by this proposal to reduce the threshold to 5%. But in many cases, we know that those other licensees also have an international Section 214 authorizations. Key issue number 3 that we identified is requiring or addressing the use of covered list equipment and services. This seeks to require all providers who have an international Section 214 application to disclose their use of equipment that are on the list prepared by the FCC as a result of the Secure Networks Act. That list is available on the FCC's website and includes some of the Chinese telecommunications equipment vendors, some video surveillance equipment vendors, as well as service providers whose authorizations have been revoked by the FCC. This would be an additional reporting requirement than the annual reporting that's required in March under the Secure Networks Act for providers of advanced communication services. In addition to requiring a disclosure in 214 applications as to whether you use this equipment, the FCC is asking whether it should require providers to notify the FCC either 30 days before or 30 days after adding or removing any of the covered list vendors from their services. So that will be an interesting aspect of this NPRM in the record. Notably, one of the key changes from the Team Telecom process is historically Team Telecom really has focused on foreign ownership considerations. And that's really what the FCC historically, the Team Telecom involvement has been focused on. But the FCC is proposing that any applications that involve the use of covered list equipment or services would be referred to Team Telecom with the need for providers to complete the standard questions at the outset of the 214 application process. And in our experience, we've seen Team Telecom inquire as to the use of this equipment during the triage process, and it could ultimately result in mitigation agreements that include removal and replacement requirements that would likely be unfunded as a condition of the international Section 214 authorizations.
If I may just use a little parenthesis here with respect to Team Telecom, you were referring to the quote unquote standard questions, which the FCC determined back in September of 2020, that what the standard questions with some back and forth with Team Telecom, what those initial questions would be and how applicants would need to respond to them as part of the application process. Unfortunately, those questions are not yet put in place, and the applications are being submitted without those. And what Team Telecom does is then they ask the applicants what their questions are with respect to specific applications. In some cases, they follow the quote unquote standard questions that have been published by the FCC. In some others, they don't. They ask much broader or longer questionnaires. And that has resulted in delays, right? Because it's not only that parties are ready to respond to, say, a list of 20 questions. If Team Telecom comes with a list of 30 questions, that takes additional time for the parties to be able to receive those questions, process those questions, and respond to those questions. So obviously, one of the areas that is important for this is for the rules that the Commission imposed in 2020 to become effective, but they have not become effective 3 years there. I mean, after the publication.
Yeah, and many of those standard questions are no longer the standard questions anymore. We've started to see additional questions beyond what was in the standard questions, or different variations of the standard questions.
Large majority of new cases don't start with that. That's a baseline that is no longer being used. It's a much more probing questionnaire, if I may use the expression.
So the next issue here that really could have an impact on international Section 214 authorization holders is proposals about requiring applicants to identify whether they use foreign-owned managed network service providers. This really originated from some policymakers on Capitol Hill have been pressing the FCC on this question for some time now, seeking information about how many foreign-owned managed network service providers are able to access U.S. networks from overseas, and the amount of access they have to personal data and network data of U.S. telecom networks. So this proposal would essentially require you to disclose your current or future use of foreign-owned MNSPs. Like the covered list equipment, it would require a referral to Team Telecom and answering the Team Telecom standard questions or triage questions in the event that the standard questions aren't approved or need to be changed. They ask also additional questions about what information should licensees have to disclose about these foreign network service providers, including ownership information and whether the licensee should be required to disclose 5% or greater owners of these managed network service providers. That may be a challenge, particularly for foreign-owned suppliers that are not publicly traded, and there's limited information about their foreign ownership and exactly who has those holdings, and other things such as character considerations and the extent of foreign involvement in their management. They're also asking whether there should be a one-time information collection. So there is a chance we could see, similar to the one-time information collection on foreign ownership, we could see an information collection about the use of foreign-owned managed network service providers in the future. But that would require additional OMB approvals and order additional OMB approvals and then a new process to have that submitted, that information. Another key expansion of the international Section 214 regime is proposed requirements to disclose use of cross-border facilities. So these would be facilities connecting the United States to Mexico and connecting the United States to Canada. One notable aspect of this is that it would be a disclosure required for facilities based as well as resale carriers, and would require disclosure of non-common carrier facilities as well as common carrier facilities. And under Section 214, that provision really only applies to common carrier facilities, but in the interest of having more information, the FCC is wanting the information about non-common carrier facilities.
And this request comes like this addition likely comes at the request of the National Security Agency. So obviously there's plenty of communications that go to Asia, to Europe, to South America via submarine cables, and the US is a big magnet for submarine cables, and they're very well controlled by Team Telecom. But to the extent that other countries like Canada or Mexico start becoming hubs for submarine cable traffic, and in order to bypass the US or whatever, and then in order to protect the networks and the borders of the United States, it's important to also have controls over the cross-border facilities with our neighbors to the north and the south. So this is an area of additional concern by the national security agencies, and I think it's rightfully so to do so in order to protect the integrity of US networks.
I think there's also an aspect to it, as we mentioned on the slide, about concerns about how traffic is being routed and whether there is some traffic that may be unnecessarily routed outside of the US when really it should just be routed inside of the US. So there has been some concern about that. I believe the FCC has a proceeding where they've sought some information about that separately. So similar to the other requirements, there would be significant details required about your cross-border facilities, including the location, who owns the facility, the equipment that's used, the services that are being provided over the facilities, and the like. And these also, use of these facilities would result in a Team Telecom referral and potential one-time or ongoing information collections related to cross-border facilities as well. So in addition to the renewal framework, the new application requirements, the FCC is also proposing a periodic reporting obligation for international 214 holders to really ensure that the FCC has up-to-date records on an ongoing basis. And this would require a periodic reporting of ownership as well as other information on a 3-year rolling process. So every 3 years, you would have to provide this information to the FCC. This gets to part of the point with the TruePhone case that Ulysses was talking about earlier, with outdated ownership information at the FCC. And really the one-time information collection here, they want to have that be a rolling process moving forward. I think most notably here is that this periodic report beyond the Section 214 application proposals and require disclosure of things like where you're storing information, the countries that those are being stored in, the equipment you're using to store the information, and where your employees, subsidiaries, and offices may be located outside of the US.
I have to note that most companies that have gone through a Team Telecom process recently. I mean, generally Team Telecom concludes their reviews with what they call a standard mitigation agreement, which takes the form most likely of a letter of agreement or letter of assurances, where the applicant agrees as a condition of license to a number of commitments, including many of the things that Patricia was mentioning, and having periodic reports to Team Telecom. What the FCC is proposing is whether also this should be done at the commission level. And the question, I think, for industry is whether if applicants already have certain disclosure obligations to the national security agencies, whether it's appropriate to have double effort with respect to the commission as well. I think it may be for administrative efficiency better to respond to one set of regulators as opposed to the other, or for regulators to be sharing that information with one another, so that the applicants or the companies are not subject to a double regulatory disclosure.
I think this also raises the issue of confidentiality in terms of where facilities are located. When you submit that information to Team Telecom, that's all treated very confidentially, whereas at the FCC, there will be procedures that you'll need to follow in order to get confidential treatment.
Right, and obviously there's, for many legitimate business reasons, not because of anything shady or anything problematic, there may be, I mean, the need not to share with your competitors where your facilities or your equipment is located for certain particular services or ideas. So I think the issue of confidentiality is one that is very key for parties to consider, particularly as we were discussing that the FCC tends to be an open book, and everything filed with the commission is generally 3 clicks away on Google.
So lastly, here in terms of substantive proposals, we highlighted some of the issues that we thought were some of the key aspects of the proposals moving forward, but those are by no means all of the proposals that the FCC has in its NPRM, and we're expecting potential additional requirements to come into place. For example, here we've listed some of these: certification to adhering to baseline cybersecurity standards. There has been a long time agreement among industry or advocacy among industry to the FCC to avoid stringent specific requirements in terms of cybersecurity. And here the FCC is proposing to require all international 214 holders to comply with baseline standards. It doesn't specifically require a specific standard, but provides some examples of those. We have other requirements: certification of compliance with the FCC rules and the Communications Act, limitations on how many licenses a company can have, requirements to commence service within 1 year under an authorization. I know there are some countries outside of the US and even some states inside of the US that have a requirement that you need to notify the commissions of your commencement of service, otherwise your license is canceled. So I don't think this is all that controversial of a requirement, but there are some carriers that just have their international 214 authorization, kind of just have it
And
just
never
in
have
case,
used it, and never have used it.
and have never used it to provide common carrier international services. One that I wanted to highlight here is requiring the disclosure of international signaling point codes. These really aren't something, Ulysses, that the FCC directly regulates, but we did see this issues of ISPCs come up in the context of the FCC's revocation of the 214 authorizations in 2021 and 22. So they do want to know if those authorizations or those codes will be transferred or impacted as a result of an assignment or a transfer of control.
And in today's IP based networks, these signal point codes may not be as used as it was in the SS7 days or other more legacy networks, but still some carriers continue to still use those point codes.
And that's another aspect similar to the 214 authority. If you're not using your ISPCs, you have no need for them, it may be worth considering whether you relinquish those.
Exactly.
So finally, I think the question is really, there's a lot of significant changes that may be coming, but when will we actually see this happening? Essentially not for quite a while still. We think at the earliest, probably Q2 2024, maybe a little later than that, maybe a little earlier, but we think that the process will still need to go through the entire rulemaking process, the ex parte process, coordination with Team Telecom. We did see Team Telecom weigh in at the FCC before the final order in NPRM was drafted, expressing general support, but a little bit of concern in terms of administrative efficiency and potential additional burdens that would be on those agencies, which I think are already stretched a little thin in terms of team telecom reviews. So that whole process will still need to go forward.
Right. I think just to underscore, I mean, what we're seeing as potential action in 2024 is the FCC changing its existing rules or implementing those rule changes as part of the proposal of the rulemaking. What we will see definitely during Q3 or Q4 of this year would be the actual comment cycle, both for industry and Encompass and its members to be able to participate and actually try to shape the rules from the FCC and explain to the regulators whether what their proposals are appropriate or not and why. I think that's the important part of the rulemaking process for industry to be able to weigh in and determine whether the proposals are burdensome or the proposals are acceptable and provide alternatives. Because obviously the FCC is trying to do their best in order to address these issues. But I think that those that are on the trenches and operating networks on a daily basis are very qualified to assist the regulators in saying, well, you're asking for X, but this may be too burdensome or too complicated, or we're already doing it in the context of team telecom. Why are you asking it twice? Things of this nature, right?
Yeah. And I think another important thing to keep in mind in terms of timing is that even after rules are adopted as a result of this rulemaking, there will still be an implementation period, likely with OMB approval required due to the number of changes in the actual applications, additional reporting and the like. So I don't think we'll see anything immediate coming from this NPRM, but definitely stuff in the future in 2024 that all carriers should be keeping their eye on.
Again, just the immediacy would be filing of comments whenever the commission opens the window for the comment cycle.
So that's all we have.
And with that, we want to thank Encompass for the opportunity and throw and see if there are any questions in the chat.
Yeah, Ulysses and Patricia, thank you so much. What a thorough and comprehensive presentation. I think the proof of how comprehensive it is that our first question did not come in until just a few minutes ago, and I did want to run through it. But I think the timing issue is well put. I think we just saw some items from the Commission's May agenda just published in the Federal Register. So there's certainly been some delays, and so appreciate you sort of setting the potential time frame for us. And we'll be looking forward in the Federal Register for members as well. So thank you for that. I had a quick question that I wanted to get to first, and then I'll get to Jessica's question. With respect to the data collection portion of the item, we talked a little bit, you all talked a little bit about the streamlined filing option. That's something that Encompass did some advocacy on. This is for licensees with FCC approval in the last 3 years without a material ownership change. Do you all anticipate the Commission providing some guidance with respect to or defining material change when it does come out with its form or once it's had an opportunity, the International Office of International Affairs has had a chance to review and look at this issues? Do you expect there to be additional guidance on material change in the Commission action?
We hope so. We hope so. We think that probably at the 10% level that would be that. I mean, in terms of the own agency's resources, right? If there's, they need to determine a minimum threshold for things to be changed or for it to be reported. Otherwise, it may become too unwieldy, and the FCC would have a hard time digesting the information that applicants provide. So it's a balance, both collection as well as absorption of that information. And obviously, the FCC has finite resources, and it will be important for the FCC to consider setting up a limit that allows them to continue with their mandate and trying to protect the U.S. while at the same time not burden themselves unnecessarily.
And I think the 10% threshold makes sense, particularly because that's the only threshold that applies currently for these providers, other than a 50% threshold, which is a transfer of control, which you would assume those licensees would be receiving approval from the FCC or providing a pro forma notice in the event that actual control is not changing. There would already be a filing with the FCC about that. So between 50% and 10%, I think 10% is more likely to be the material threshold for that reason.
Great. Well, thank you both. Okay, our next question comes from Jessica Esquerra. Do you anticipate the certifications with cybersecurity and compliance to be combined with the 3-year reporting requirements because of the parallels of concern with security, or will they be implemented with application and 10-year renewal only?
I think it will be, I mean, still up for debate, number one, but definitely as part of application or transfer or renewal, the FCC would likely want to impose those. Whether it becomes a 10-year versus the 3-year reporting cycle, still TBD. But definitely the FCC does want to make sure that those certifications are made at least at the applications phase or at the transfer phase, whenever the company, or renewal phase, when the company is subject to such events.
Great. Well, that's all the questions that I have listed. We've still got, I have a couple of quick wrap-up announcements to make. So if you do have a question, now is the time. Really appreciate Ulysses and Patricia's expertise here and their delivery of a fantastic presentation. It's always great to host one of these webinar series, particularly on such a timely topic. So I wanted to just thank you both for your work on this. And I know that we'll be following this for into the foreseeable future. So thank you both so much. I wanted to mention, obviously, that this webinar is being recorded and will be included on the Encompass YouTube channel. If you are watching us on YouTube, then congratulations, you're there already. And please check out some of the other Encompass webinar series videos that we've got below. And this will be just the latest in a continuing series of webinars that we'll have on important policy topics that Encompass members are following. Second, I wanted to remind everyone about the Encompass show. Please register for the show coming up in Tampa, Florida, from October 8th to October 10th. We're looking forward to seeing everyone there. And then if you have any suggestions for us on our web series, or if you have any follow-up questions, please feel free to email me at cshipley@encompass.org. We'd be happy to take suggestions, or if you have a topic that you'd like to cover on the series, we'd love to hear from you. So again, thank you again to our presenters, to Ulysses and Patricia. Thank you both so much. We hope you all have a great rest of your day, and we will check in with you again soon. Thanks so much.